Great. So Judge Hansen, thanks for taking time this morning to meet with us here at the Apartment Association. We appreciate you taking some time out of your day to discuss some questions here on how evictions are going to be going here as we move forward.
Yes, sir. I appreciate you having me.
Great, great. Well, hey, just to get started, a couple questions here for you. So first off, I can only imagine as you guys have been shut down that you're experiencing potentially some sort of backlog on evictions. Can you maybe expand on any backlog you're experiencing there?
Sure. It's, as you know, it's a complicated, complex situation, and they keep changing dates on us. We get ready to go, and then they move the date back. But the bottom line is the Texas Supreme Court and the politicians are going to decide when we start this back up. As far as backlog, Drew, I've been actually surprised. I was expecting anywhere from 100 to 150 cases to have been filed by now, and we've literally had only 10 or 15, which tells me one of two things. Either the situation, I don't know if the landlords and the tenants are working together, I don't know. But what it may mean is that we're going to have a mass influx starting next week into our offices. I'm encouraging people who file evictions to get the information from this video and to mail it in if they want. We are social distancing. We're taking steps to ensure public safety here at the courthouse. But because of those small numbers that I'm seeing, I'm a little bit fearful that we might get slammed next week with some long lines out the door.
Well, I hope you're right. And primarily tenants and landlords are working together during this time. I know we've been encouraging our members to do that. And I think we've seen great response from most of the membership base in trying to work things out. So I hope that continues. So speaking to potentially that onslaught of many cases coming, do you have a feel on the timing we should expect from filing to when the hearings might be? Do you have a feel for that?
Yes, I do. May 19th is going to be the first day. Well, you can file an eviction today. There's not a shutdown on filing evictions, and we're open from 8 to 5, closed during the lunch hour during the Corona period. But May 19th is going to be the first day we can take action when the clerks begin initiating actions in a case. And the first action we initiate is to file a citation. That's the notice to the defendant, hey, you're being evicted. Once we get those out, the constable has to serve them. We have one constable, but we're looking at setting hearings as expediently as possible in JP1. For us, we will be setting hearings in the latter part of this month and into June. And usually I only have evictions twice a week, but I look to have them 5 days a week once we get up and running until we get through that backlog.
That's great. Well, appreciate you trying to push those forward as quickly as possible. So you mentioned social distancing, and so you guys are open for walk-ins. And therefore, is there any kind of protocol set in place right now for required PPE that anybody needs to be aware of if they have a hearing?
Right now, it's suggested that everybody wear masks when they come to the courthouse. I don't think you'll be refused entrance if you don't. What we had is to put a big plexiglass door on the front of my office, and it has a slot in it. And the person is as close as you and I are virtually right now, and we can hear each other just great. And we have that slot, and if you're going to pay with a credit card to file an eviction, we can hand the credit card machine through. But that's worked fantastic. And we also have some new office furniture that we're going to have in the works either later this week or possibly next week. But using the plexiglass door has worked. We have markings on the floor to keep people at least 6 feet apart. But again, Drew, what I would strongly encourage is the person call the precinct where the property is located, get all your questions answered over the telephone. How much is this going to cost? Well, how many tenants do you have? 2. Well, that'll be X amount. Get all your questions asked about the CARES Act affidavit, about when the hearing is going to be held, et cetera, so that you can minimize your time here at the courthouse.
Sure, that makes sense. And so you mentioned earlier recommending perhaps that people call ahead, and they get all their information, and then is the best procedure for filing right now, in your opinion, to mail it in or by phone or in person? What would you recommend on that?
Well, you really only have 2 options, either to come in and personally file it because you have to pay for the eviction, or mail. And I strongly suggest mail, but again, we won't turn anybody away 8 to noon, 1 to 5, Monday through Friday, if they want to come in and file through our plexiglass door.
So starting the 19th and later into the month, you'll be having hearings in person, and that's y'all's goal moving forward, correct?
Actually, no. All hearings, I believe the first date that the Texas Supreme Court is saying we can have in-person hearings is June 1st. What's going to happen May 19th and in this 2-week period when I'm catching up with the backlog, all hearings are telephonic. Obviously, we're talking, I have Zoom capability, but as I kind of perused the idea, I thought that maybe landlords and tenants might have some technical difficulty negotiating Zoom. So telephonic seemed to be the best way to go. What we're going to do when the landlord comes in and files an eviction suit, we're going to have the landlord provide us with a phone number. We're going to say, your hearing is going to be at this time and you're going to be at this number, correct? And they're going to say, yeah. We're going to mail a detailed letter to both the landlord and the tenant. The detailed letter explains to the tenant that it's a telephonic hearing and that they have until the day before the hearing to give us a good phone number. If the hearing date comes, the telephonic hearing, and I call the landlord's number and they do not answer, it's just like a no-show in court. If the landlord answers, I connect them through conference call to the tenant. Likewise with the tenant, if they do not provide a phone number to me, or if they do not answer the phone when I call, it will be handled the same as a default judgment. I think this is really going to be a good workable thing. And with some folks on your end that I've talked to, they like the idea. If you have a property management company out at 82nd in Milwaukee, you'd rather sit in your office and do the eviction that way rather than come down here and sit in a crowded courtroom with 10 or 12 other landlords. That's why we're doing the telephonic hearings. And it's my hope, I'm not sure of this yet, it would have to be enacted through legislation next year, but it's my hope that the Supreme Court in the meantime extends us that capability to do hearings telephonically, not just for evictions, but for debt cases, small claims, etc.
So that capability to do over phone is currently in place through June 1st, as you mentioned. And then the plan after June 1st, as of right now, is to get back into the courtroom and do the hearings in person.
Well, it's May 19th. From that date, everything's going to be telephonic. June 1st, subject to change by the Texas Supreme Court, is supposed to be the first day that we could again have in-person hearings. I don't know if I'm going to have those in-person hearings or not. We'll see how this works telephonically. I also forgot to mention, if you have an eviction and you have a witness, which we often do, you'll also have to provide us with that witness's phone number so we can loop him in. And the letter that we send out also explains to both landlord and tenant if they have exhibits, obviously the lease, maybe a docket of the payments, then they can email us that and get us the phone number of the witnesses, and we'll proceed just like it was in court.
Well, good to hear. It sounds like there's a good process put in place, and excited to see how that kind of plays out. So now my understanding is there is a new CARES form that has come out and that is requested to be submitted when you file for an eviction. And my question is, do all evictions require this CARES form, or is there a date precedence to where if you file it before some date, it doesn't need it, and maybe after a date, and how much longer is this form necessary? Can you speak to that?
Sure. The best way to tell you about the CARES Act is to first tell you the 3 things that the CARES Act does not apply to. I've got it written down here. It does not affect eviction cases that were filed before March 27, 2020. It does not affect evictions with purely private landlords, with none of the following I'll describe in a bit. And it does not affect eviction cases for non-rent issues. That being said, no eviction can take a judgment without a CARES affidavit. You have to have a CARES Act affidavit. In my precinct, I won't speak for the other 3, but it is required by statute. You can't take a default judgment even without a CARES Act affidavit. What the CARES Act applies to is from the Violence Against Women's Act, and applies to public housing, Section 8 housing, housing choice vouchers, and it also applies to federally backed mortgages such as HUD, Fannie Mae, and Freddie Mac. But the HUD, Fannie Mae, and Freddie Mac, those are primarily foreclosure evictions. For the purposes of apartments, really, if you're a purely private landlord and you know that the CARES Act does not apply, it's a fairly simple measure to just fill out the CARES Act affidavit. But I have complete factual knowledge that none of this applies to me, and have it notarized. It's a sworn affidavit. You're swearing to tell the truth, and so obviously you should tell the truth with the threat of perjury over you. But that's the way that's going to work.
Good to know. Good to know. So bring your form in when you file, have it filled out prior to, and that's for any eviction case after March 27th, filed after March 27th forward. If you file maybe without knowing about this CARES Act form, are you, as the court, going to notify those who filed without it and kind of make them aware?
Absolutely. If someone files by mail and they fail to submit a CARES Act affidavit, I've already prepared a CARES Act packet. My clerk will call them and explain what I just explained to you, that it's a requirement of law that you have to have the CARES Act affidavit. We'll answer all their questions about it, and I'll email them that packet. If you're going to file in person, don't sign your CARES Act affidavit. Get it all filled out, but you can notarize it in front of my clerk, obviously at no fee.
Good to know. So you mentioned earlier we're getting concerned of a potential onslaught of a lot of cases coming, and wanted to talk a little bit more about that and really kind of get your thoughts on how you're going to potentially prioritize those hearings, those cases. Do you foresee prioritizing violent and potentially dangerous tenant issues, prioritizing those first? Or are you going to take those cases out on just a first come, first served basis?
Well, actually, the only cases that can be filed right now, today, are imminent threat eviction cases. I've had, I believe, 5, and I have heard telephonically 5 hearings along that line. And the imminent threat petition is available from us. It has to be an imminent threat, obviously. But I have a hearing ex parte with the landlord to discuss the threat. Usually it involves police reports. The 5 that I've heard, some of the facts on those were pretty serious. I make a determination after talking with the tenant, or the landlord rather. If the imminent threat exists, I proceed to trial. And the trial, I've already held several trials. If imminent threat does not exist, I have to set the case for May 19th or beyond as a regular eviction. If a bad faith petition is filed, then I impose sanctions and can hold the landlord in contempt. That has not happened yet, but that's the way that works. We've had several filed now, and an imminent threat or public safety petition is the only thing that you can actually file today.
Sure. So as we come past this May 19th deadline, how do you foresee the prioritization going of these imminent threat cases versus just maybe more traditional non-payment cases?
I think we have a few in the queue. We have several that are just sitting on a desk gathering dust until May 19th. My plan at this time is to file the cases in the order in which they come in and are presented to us.
Good to know.
Another thing, if I could mention, a lot of landlords are wondering about the coronavirus situation, and do my rulings differ? Are the rules different now? If you think about what we've gone through with COVID-19, it's like a pause button was put on eviction cases back around March 23rd. The pause button is going to be lifted, other than imminent threat petitions, on May 19th. The rules do not change. I still have a burden, the landlord has a burden beyond the preponderance of the evidence. I still use the property code and the Texas rules of civil procedure. And the way I will view cases does not change. If you've ever been on a jury, jurors are told, you swear an oath where you do not let bias, prejudice, or sympathy play any part in your deliberations. It applies to judges as well. We don't say that all the time in court. I don't let bias, prejudice, but it is a fact. And way before this, 5 years ago, I've been here 30 years, and I've heard some terrible situations where really good tenants got in really bad situations. For example, a car accident and they lost their job, medical bills, cancer, etc. And I'll be ruling on cases where the evidence leads me, the preponderance of the evidence leads me, and nothing is going to change. I'll be doing cases after May 19th, the same as I did in 2019, 2018, etc.
That's good to hear. I appreciate you expanding on that and making that clear. We've been reading and hearing about other municipalities around the state talking about having delayed rulings or working to rule for not repossessing the property, and instead trying to work out a way where tenants and landlords are required to maybe work through a payment program or payment plan. Do you have any insight on that, on your court, and how y'all will be looking at non-payment evictions in the future? I know you just kind of spoke to that a minute ago. Do you have any other further insight into that?
No, as I say, I know that in some municipalities, cities have passed ordinances. In some counties, the county judge has issued an edict regarding evictions. I don't think that's going to happen here in Lubbock. I'm going to go back to doing evictions the same way as I did before. Obviously, I always encourage landlords and tenants to work together, but I'm sure not going to be banging the gavel saying, by golly, you have to accept $25 a week until everything's paid up. That's not my job. My job is to listen to both sides and to make a fair and firm ruling, and I'll do that.
That's good to hear. Well, thank you for clarifying on that. And so lastly, kind of the last question I have here for you, Judge, is do you anticipate any delay in reopening the courts? Have you heard anything from the Supreme Court here in the state that's going to maybe push this past May 19th?
Well, on May 1st, which was the last deadline, I was ready to go. We met with the constable, my staff. We had a big meeting, discussed the protocols that you and I have discussed here today, and we were ready to go. 4 days before that, April 27th, I was at home with my lovely wife, and I got the notice in my email box that it had been extended. That was the evening of April 27th, and it was supposed to start May 1st. We're 5 days out right now, and I don't know. I was actually kind of shocked when they, at such a late date, pushed the May 1st date back. I will tell you, I think if they do extend May 19th, and I have no indication that they are, I don't think they go back past June 1st. June 1st was the date when all this started. That was the magic date when this was all supposed to end. But everything I'm seeing and hearing right now, Drew, indicates May 18th, actually May 19th is going to be the go date to begin hearing cases. But I heard the same thing May 1st, and we saw what happened there. But I'm ready for May 19th. If it happens, it happens. If they surprise us with another 11th hour surprise, we'll deal with it.
Well, good to know, Judge. Well, thank you for that. And so just to end our conversation, do you have anything else that maybe I didn't cover in the question that you would like to make our members aware of as we move forward?
I'd strongly encourage folks to look at my website, Judge Jim Hansen. If you don't spell it right, you're going to get Jim Henson of the Muppets. But if it's Judge Jim Hansen, Hansen, it'll take you to my website. There's a Corona link on the main page. Email me with any questions, not with your specific situation with a tenant, but if you have any procedural questions, email me and I'll be happy to answer those. I'd strongly encourage you also to contact the court where the property is located. I can only deal with Precinct 1, and the JPs, on some rules, they vary a little bit from court to court. So it's best that you contact the source rather than contact me and then go to another court and they say, we do it this way. And, well, Judge Hansen told me. It doesn't matter what Judge Hansen thinks. I can only make determinations for Precinct 1. But I'd strongly encourage people to email if they have questions, to look at my website and to read up on it. And we'll do our best. Once we get started back up, it's going to be interesting and tough at first, but we have a very dedicated staff, very dedicated constables, and it's going to be priority one to get these cases scheduled and heard.
Well, thank you for your time, and we really appreciate everything you do and your court does, and we look forward to maybe getting back to some sense of normal here in the future. And we'll be sure to put a link to your website on our website as well, and that we make that available to everybody. So if you want to go to our website as well at lbkapts.com, lubbockapartments.com, we'll be sure to put links there as well. And so, Judge, thank you so much. Hopefully you continue to stay safe and healthy, and we'll talk soon.
Same to you, sir. Thank you for getting the word
Thank you.
out. God bless.